We don't have all the facts and circumstances concerning the alleged act of recording at the McDonald's. It is pretty much settled as a matter of law. 2015, Wisconsin, a registered sex offenders from intentionally photographing minors because the statute was deemed unconstitutionally overbroad. Now, that's not an issue exactly parallel in that respect to this here today. The Oatman court described some scenarios and went on to illustrate examples of innocuous and constitutionally protected photography, such as newspaper photojournalists capturing images of children meeting with politicians, professional photographers taking school yearbook pictures, and proud parents photographing their children with classmates on the first day of kindergarten sharing with the grandparents. Photographs are routinely taken of people in public places, including at public beaches where bathing suits are commonly worn, and at concerts, festivals, and sporting events. Taking pictures of people at such venues, including a swimming pool at a public park, is not unusual, suspicious, or criminal. Now, in the Oatman case, the photographs were non-obscene, non-pornographic images taken of children in a public place. So there is some level of constitutional and protection to be discussed here. Now, having said that, they collide with the longstanding position of the court that obscenity is not protected by the Constitution. So far, we've had no indication that obscenity is on the table here. 38, in the Texas Court of Criminal Appeals again, Ex parte Thompson, the camera is essentially like the photographer's pen or paintbrush. Using a camera to create a photograph or video is like applying pen to paper to create a writing or applying brush to canvas to create a painting. So as we look at this, there is that constitutional dimension here with regard to whether Mr. Lote's conduct is protected or not protected. That's only part of the puzzle. Not protect a man in falsely shouting fire in a theater causing a panic. Thus, not all speech and conduct is protected by the First Amendment. Reduced to its bare essence, that issue in this context is whether the defendant's conduct on February 4th, 2014 at McDonald's was the functional equivalent of yelling fire in the crowded theater so as to overcome any constitutional protection. And so to kind of put that into a context nearly 40 years ago, would that be the same as McDonald's here? Obviously, people take photographs in McDonald's all the time. There are birthday parties, there are celebrations, people take selfies. But as Mr. Calderon had pointed out, generally these people kind of know each other, and it's not the type of conduct that would alarm someone. To put that into some, is whether the protected conduct of photography is attenuated by other factors, including perhaps the defendant's own conduct in exercising his right. So, for example, First Amendment rights exist in public places. They exist outside the City Hall here. To a certain extent, they exist inside the City Hall here. But do they exist inside the restaurant a block and a half up? And when a shopping center owner, for example, opens his private property to the public for the purpose of shopping, the First Amendment doesn't create individual rights and expression beyond those already existing. Pruneyard Shopping Center versus Robbins, 447 U.S. 74. So at some extent, we have a difference because this is not a park, it's not a beach, it's not a public place. it's not an entirely private place, but what's the reasonable expectation of privacy in such a surrounding? So now, it's still left to be seen whether or not photographs were actually being taken. That's a point in dispute in the evidence here. But I do want to discuss that whether or not there's ancillary conduct which would have pierced a constitutional protection, or does that constitutional protection extend into private property, even that property is held open to the public, such as in McDonald's. Now, there's some limiting cases, for example, about communities that are literally company towns, where the company you work for owns everything in the town, and the Supreme Court has come back and said that's a little bit different because the things that take character of a public place are privately owned, public property. But that's a situation that we really don't have here. So that's something that, as we look at this, it's certainly understanding why people may be alarmed, but we have to look to see whether or not the defendant's conduct pierces those implications, or if those implications apply on private property in the McDonald's. That said, we may not even have to look into this issue at all. Both Mr. Calderon and the defendant have admitted participation in an incident in which, so far, the evidence by the defendant's own admission and by Mr. Calderon's own admission is that they were both disorderly. Regardless of whether or not Mr. Calderon was appropriate in challenging the defendant inside the restaurant, they both ratcheted up their conduct to the point where they were profane. They used the type of language in front of children that case law has clearly indicated is disorderly conduct in and of itself. Based on the record that is before me at this point, if the testimony ended right here and right now, I don't have Mr. Calderon's case in front of me, so I can't comment on his conduct, and I could certainly understand Mr. Lote's concern with regard to that, but he essentially did almost exactly the same thing in being profane, loud, confrontational, clearly the type of conduct within the restaurant and viewed by children a few feet away that would clearly be disorderly under 947.01 or the ordinance adopting it. And that's by the admission of both of these men, notwithstanding any of the other issue with regard to the photography. As for, and I'm not precluding, by the way, discussion of further issues or testimony, but I want to at least clarify where we are at, because there's two elements being looked at. You know, two kicks at the cat, so to speak. First, was the alleged recording of the child inside the McDonald's that Mr. Lote denies so far doing disorderly conduct under the circumstances as they then existed? Are we sure about that? I don't know. Do constitutional protections extend? Again, that's still an open question and undecided. But so far, by pretty much the admission of the two relevant parties here, there definitely appears to be disorderly conduct, irrespective of the videotaping incident, even though looking at the evidence in the light most favorable to Mr. Lote, he was certainly provoked. Mr. Lote says that he was defending himself. There was not a battery. And his way of defending himself appears to have been essentially to mirror tit for tat the same conduct that Mr. Calderon. And that testimony is undisputed by both parties. You know, they were pretty much equal. for all intents and purposes. So I'm wondering at this point, is this an exercise in futility with regard to the issue of the recording if in fact both of these individuals engaged in disorderly conduct? I understand Mr. Lote's point, and I'm not making a final decision at this point. I'm inviting discussion. And the other salient point in that is that I recognize that there is a aspect that can be raised of self-defense or defense of third parties, and that's not being foreclosed. So certainly that can be discussed. However, I guess the thing that I look at, Mr. Lote, assuming that Mr. Calderon, for purposes of that argument, if in fact he deemed Mr. Calderon's conduct to have been disorderly and offensive, he did have the right to either call the police or make the arrest on his own. In fact, one of the seminal, but there were some things that Mr. Lote could have done other than throwing gasoline onto the fire. So certainly he's free to raise the argument of self-defense, but the city could certainly raise the issue of Mr. Lote's conduct. So with that in mind, first,
Thank you, Your Honor.
Ms. Iceland.
Thank you. Your Honor, as far as the city's evidence, the further evidence that the city would present, it would basically be not as to the photographing section, but to the disturbance of the patrons, the customers at the McDonald's restaurant. And the city basically has both the mother of the child here who would testify as to the language that was used by both parties and the disturbance that was created at the restaurant. Also, her fiance is here, would basically also testify as to the disturbance that was created. Neither of these parties witnessed the actual recording of the child. So
Right.
that portion would be. We have the officers here who would tell the court how their investigation proceeded and how they identified Mr. LaHote. And as well, we have Mr. Peters from the McDonald's restaurant.
And some of that obviously is duplicative of what's already on the
Certainly.
record. And in fact, whether or not an actual disturbance existed, the statute and the ordinance is satisfied if it's conduct having the tendency. People talking about beating each other's ass and calling somebody a sick motherfucker and you know the various other language that went back and forth right then and there, if there's not a classic disorderly conduct that tends to cause or provoke a disturbance, you know, I fail to see, based on years and years of experience, you know, something of that nature. But that said, you know, like I said, that evidence may be cumulative. Now, it's Mr. Lote's trial, though, so let's hear from him.
Oh, can I just add
Sure.
one other thing, Your Honor, though?
Nearly 100 years ago, that fire in a crowded theater, Justice Oliver Wendell Holmes wrote, well, he meant something. And so the question is, at what point, you know, is there the fire in the crowded theater? The not on it, don't get me wrong, to refute what is on the record so far. And the second case scenario, the subsequent conduct, would be sufficient to convict either of you, probably, of disorderly conduct. Unless, of course, there's something that you can argue to either defeat that, either through the facts didn't exist or you have a valid defense. So, indeed, I'm not foreclosing that by any means, nor am I foreclosing the city from being heard on that point. That seems to be bringing the matches and the gasoline to the party, but the fire seemed to have been lit as a result of that. So, and I guess there's the old saying that your mama never said two wrongs, did they ever tell you two wrongs make a right? So with that in mind, Mr. Lowe, what are your thoughts here?
I've waited a long time for this
I know you
day,
have, and that's why I
and I am
jumped in
willing to
here.
continue with this trial. We've barely scratched on the evidence that's available to us to determine exactly what happened. I'm waiting for the surveillance cameras to fire up so I can point out exactly what happened in the chain of events. Mr. Corleone is lying. He straight up attacked me in the store and tried to rob me and threatened to kick my ass. Mr. Corleone is
Well, he admits that he threatened to kick your ass.
Absolutely. And he tried to steal my property. He's a very large man, and I have every right to defend myself. And I did. This is not a matter of just two people sitting in a bar and they get in an argument because of a football game.
All right, fair enough.